Breaking from the Constitutional Law Desk, a federal judge says there's probable cause to hold the Trump administration in criminal contempt for ignoring his order to stop 2 deportation flights. Here's why that's more than a procedural skirmish and what it means for everyone who relies on courts to protect their rights. First, the facts. On March 15th, the White House invoked the 1798 Alien Enemies Act, a wartime statute that lets a president remove non-citizens with almost no process and put more than 200 Venezuelan men on planes to El Salvador. Minutes later, U.S. District Judge James Boasberg issued a temporary restraining order, or TRO, telling the government to turn those planes around and give the men access to lawyers and hearings. The administration has let the flights land anyway. So Contempt 101. The Constitution gives federal courts the final word on what the law requires in any individual case. When the executive branch disobeys a valid order, that defiance is contempt of court, the judicial equivalent of saying, hey, your move, Congress and President, but this is my lane and you crossed it. Civil contempt is meant to coerce compliance. Criminal contempt punishes the past violation itself. So Judge Boasberg is signaling that he may move to the punitive track because the disobedience was, in his words, quote, willful. So what about the Supreme Court? Well, a week ago, the court vacated Boasberg's TRO on jurisdictional grounds, right? The migrants were held in Texas outside his district. Important nuance, though, vacating the order doesn't wipe away what the administration did while the order was live. So under long settled precedent, think Walker versus City of Birmingham, a party must obey even a flawed injunction until it's reversed through proper channels. Ignoring first and litigating later upends the rule of law. Next steps. The judge has given the administration until April 23rd to explain how it will, quote, purge the contempt, most obviously by bringing the deported men back into United States custody so they can file habeas petitions. If the response is inadequate, Boasberg can compel sworn testimony from officials, impose fines, or ask the Justice Department or an outside lawyer he appoints to prosecute executive officials criminally. It's extraordinarily rare, but the power exists precisely to keep the executive from becoming the sole judge of its own authority. So why this matters beyond immigration. If a president can nullify court orders whenever they prove inconvenient, then every statutory right we rely on, such as whistleblower protections, civil service safeguards, anti-discrimination laws, becomes a paper shield. The case is a live action lesson in the separation of powers. Courts interpret the law, the executive enforces it, and neither branch may hijack the other's role without destabilizing the entire constitutional structure. I'm Sean Southworth, a federal employee, attorney, and mindfulness-driven advocate for the rule of law and its values. Please follow us for clear, calm breakdowns of the law and flashpoints shaping your rights, because staying informed, I think, is the first step towards staying protected. If you're interested in making sure to get more information like this, please feel free to join our newsletter by going to the link in my bio. It's the first link there. Or you can go to fedlegalhelp.com/newsletter. Thank you, everybody, and I hope the rest of your day goes well.